right, good afternoon, everybody. Uh, my name is Mark Carter. I'm a partner with Buckhalter here in Atlanta. I serve on the board of the construction section for the Georgia Bar with Todd Hefner, who usually leads these off. So Todd was unable to attend today, so you get the B team. Before I introduce Bill, I want to make sure everybody knows of some upcoming events that we have. Uh, Further to the Construction Law 101 programs, we have project scheduling and schedule claims on March 20th, bankruptcy and construction on April 3rd, and introduction to construction dispute resolution on April 10th. Um, you're probably going to get, or you will get emails with sign up information and links for these. So look forward to these presentations and hope y'all can attend those. It's my pleasure to introduce Bill Shaughnessy. He is a partner in the construction team at Jones Walker, and Bill is going to be talking about payment procedures and the role of construction lenders today. So Bill, take it away.
Great. Thank you, Mark. Thank you, everyone, for being here today. I know we've got a good turnout, and we've only got an hour, so we're going to get right to it. But the topic today, as you can hopefully see on the screen, is payment procedures and the role of construction lenders. And Mark and I were just talking about beforehand that this is a topic that doesn't get usually a lot of attention in the construction section CLE programming that you see at the Atlanta or Georgia Bar, but it probably should. And I'm glad this one made the lineup. And I appreciate Mark and Todd Hefner and the Georgia and Atlanta Bar teams for putting this series of programming together. Something unique, and I think the content has been fantastic. So I'm happy to be a part of it. So for the goal for the next hour, it's pretty straightforward. I'm going to focus on giving a working understanding of how construction lenders they may think, how the lender's requirements in the loan agreement shape the payment process down to owners and contractors on the project, and then what that means practically for the contracts you're drafting and any disputes that you may be handling for the owner or contractor. And for context of the discussion today, I want to make clear of kind of what I do in my practice, but for my time and what I do is roughly about 70%, I'd say, dispute resolution or litigation representing owners and contractors, and 30% transactional work. And so I don't sit at the lender side of the table. And what that means today for the presentation is I'm bringing more of an owner or contractor view as outside counsel, but then understanding how those lender dynamics play out in the active projects that I'm involved with for my clients and typically in contract negotiations and or disputes. And so several of the points I'll cover today are lessons that I've learned on recent matters representing the owner or the contractor. And then second point I just want to make before we start is just kind of a big picture takeaway. And I think there's value here, and I would recommend everyone kind of consider this on your future projects, right? Is stepping back and viewing the entire construction project, whatever your role may be as a whole, when you're negotiating your contract or in the event of a dispute. I think as construction attorneys, it's easy to stay narrowly focused on the needs of your client and the four corners of the construction contract that you're involved with. But on a finance project, the payment cycle, it's going to begin and end with the lender. It doesn't necessarily just involve the owner and contractor. And so the lender is a central participant in every payment decision that's made. And so understanding how they think, what they're watching, what triggers their involvement can kind of help complete your role as an advisor to your client, whatever party you're representing on the deal. I think questions can be welcome in the chat, although it may be difficult for me to see, and it'll probably be easier if I can address them at the end. I'm going to try to get through this timely and make sure we cover everything. But here's how the next hour is structured. And it's broken up into three sections, although most of our time is going to be spent in section 1 and section 2. So section 1 is covering the construction lender role. Generally, I'll touch on how lenders evaluate projects before they commit their funds, talk about the draw process and how that works, some of the legal instruments your client, for example, the contractor may be asked to sign from the lender, and then how lenders are going to monitor the work during construction, and then some common areas for where a loan draw may be frozen. And then section 2 is more of the contract work. I'm going to primarily focus on 3 foundation documents that you should know or be familiar with if you're representing the owner or general contractor. And then I'll spend a few minutes on key contract clauses, a drafting checklist, and then touch on some Georgia law, specifically on mechanics liens, prompt pay, and pay if paid provisions. And then section 3 is trying to tie that kind of all together at the end, and have some key takeaways. And then the one final point I'll make before getting into the slides here is, and this was in the marketing material that I know Todd Hefner sent out, and the comment, and I thought it was appropriate, was that construction companies exist to build things and to make money for building things. And so what shouldn't be overlooked, whether you're a construction attorney representing the lender, the borrower, the contractor, is that the payment procedures and the role of the lender can be one of the most important determinants of the success financially of the project. Your contractor could do everything right on the job site and still not get paid, or be delayed in payment because that payment process is broken down. And so closing that gap is what we're going to focus on today. So section 1 is just going to be covering the lender, who they are, how they think, and why they control your client's payment reality on the project. And to understand why that matters so much, these are rough numbers, but the online numbers, doing some research ahead of this, was that roughly 70 to 80% of commercial construction projects are funded by a third-party lender. And so that means on most of your deals, your client's working on, there's a lender sitting behind the owner controlling the flow of the dollars on the project. And then the lender's security deed, in Georgia, the security deed, in other states it could be the mortgage, is recorded before your client is going to break ground, right? So they're first in line on the collateral, and every payment process, runs through their approval process. And so the tension that I call out here, and that's practically important, is that the lender holds the funds, they have first priority on the collateral, but they have absolutely no contractual obligation to make sure the contractor gets paid. And so that gap between who controls the money and who is owed the money is where construction attorneys can really step in and benefit their clients when negotiating these deals. And there's some real protection that we're going to talk about kind of going forward. And it's kind of an underlying theme, I think, of the presentation today. So I'm going to start with the lender's evaluation of a project. And of course, I'm going to be speaking very generally, high level. But from the underwriting analysis, the lender is going to start there and conduct, their due diligence of understanding the project and the loan documents. And one of the first thing the lender is going to look at is the project type, right? Because the entire underwriting framework could shift depending on what's being built and what they're involved in and investing in. And so, for example, a condo development is going to be underwritten on pre-sales of units, maybe for residents coming in. A hospitality project is going to be driven by projected revenue and potentially brand flag requirements for that, for example, a hotel. An energy project, or for example, a wind farm or a battery storage facility, that's underwritten on long-term power purchase agreements and offtake contracts, where the milestones are based on funding tied to specific construction and commissioning events. An infrastructure project may involve government contracts, and it's kind of an entirely different collateral structure. And then a mixed-use project may layer all those complexities simultaneously or overlapping. So the project is going to tell you a lot how the lender structured the loan, what draw conditions to expect, and then where the financial pressure points are more likely to appear. And then beyond, and this is what the slide I think kind of shows, is beyond just the project type, the lender is going to look at the borrower, right? Their track record, the strength of the entity behind that deal, and whether the principals have successfully delivered this type of project before. And then, that component is that financial profile of the owner, right, may inform not only the owner but the contractor of how aggressively you can negotiate some of the payment protections in the construction contract. Whereas a well-capitalized developer with a extremely impressive track record is just a different party than a first-time developer, right, on a single-purpose LLC. And then the lender is also stress testing whether the project can service the debt. This is a little bit into the weeds, but from a construction attorney standpoint, the practical signal, I think, is kind of simple, that if draws start coming in late and the owner starts asking for billing deferrals, there could be a cash pressure problem, not necessarily an administrative one. And so if you're the contractor, recognizing that early, putting the owner on notice, and evaluating your stop work rights under the construction contract are all things you could consider or negotiate into your deal. And then finally, on the slide is market feasibility, right? And the lender wants confidence that the completed project is going to generate enough revenue to repay the loan. For your clients, projects with hard pre-lease or pre-sale commitments, they're going to have hard delivery deadlines baked in there, right? So that pressure is going to flow downstream in the form of more aggressive schedule commitments and very likely liquidated damages. And so when you see those pre-lease commitments, you need to understand kind of the certainty that's going to be required of the lender and the owner when it comes to schedule and the LD provisions. All right, so moving forward, I'm going to take a look at the kind of construction specific factors that can affect whether your client gets hired and whether they keep getting paid on the project. And this is where the lender's requirements start to intersect with your construction client's kind of everyday reality and negotiation of the contract. And so I'll start with the contract type first, right? And why that matters here. And so lenders, not surprisingly, right, they're going to prefer certainty of cost. So that's stipulated lump sum, or it's going to be guaranteed maximum price contracts, GMP, where the budget is set. And when that's the case, the lender knows the maximum exposure from day one, pretty closely, right? Assuming change orders may occur, but they can underwrite the project with more certainty. And then on the other hand, the cost plus model is a fundamentally different risk profile, right, for the lender. The final project cost is open-ended by design, so the lender can't fix the loan amount or accurately model that contingency. And so each draw may require budget evaluation or reevaluation. And if your client, from a contractor standpoint, is entering into a cost plus arrangement on a finance project, you have to expect more open book accounting, more inspector visits, right? A lender is likely on large deals hire a third party consultant or inspector to perform that work for them, and then just more administrative friction when it comes to the GMP or a lump sum project. Moving over to the right, top right on bonding, many lenders are going to require as a condition of closing that the owner ensure that payment and performance bonds are in place on the project. That requirement flows downstream then into the construction contract, and the owners are going to typically require the contractor to procure and deliver those bonds. And then the lender is typically required to be identified as an additional obligee on the performance bond. And then that gives the lender a direct claim against the surety in the event the contractor defaults mid-project. And so the payment bond serves a distinct function as well. It's going to protect the subs and the suppliers from non-payment. And for the lender, right, that's reducing their exposure to potential mechanics liens that would otherwise freeze the entire draw process. So the bond protects the lender twice, the completion risk and the title risk on the property. And then a final point here from the lender's perspective is that, a surety's willingness to bond a contractor is itself a form of kind of independent financial underwriting that lenders can pay attention to. So if a contractor gets bonded, or if it can't get bonded, or if it only has high premiums on that bond, well, that's information that the lender wants to know, and it's probably going to follow that contractor going forward on future deals. Moving down to the bottom third there on the left side on plans and specs. The lender, they want to understand, and this is kind of prior to loan closing or contract execution. They want to understand the status and completion of the design before closing, and not necessarily because they're going to scrutinize or fly spec the design itself, but because an incomplete design at closing means that the project budget could be underfunded, right? Scope gaps discovered mid-construction become change orders. Change orders that are anticipated in the original budget are going to create friction on draws that are going to be released by the lender. And then on larger and more complex projects, lenders are going to rely on what is typically their own risk management team, and then sometimes, like, as I mentioned just a minute ago, engage third-party consultants or cost estimator to test that construction budget. They could get involved with environmental or permitting reviewer issues that could come up on the project. And, I don't think that's necessarily universal, but the level of diligence that the lender is going to do is depending on the size of the loan and the complexity of that project. But I think regardless of the project size, if there are material gaps, I think big picture, if there are material gaps in the design documents at closing, then the lender is gonna flag them. They should flag them, and your client should flag them too, because that's just going to create more issues down the road. And then finally, on the bottom right there is retainage. I'm sure most of you on here have a good understanding of how retainage functions between the owner and contractor. And I think what's worth adding here is kind of the lender's lens, because it directly affects how that provisions need to be drafted in the contract documents. And so from the lender's standpoint, retainage is part of that loan risk management. It's a completion reserve that they're counting on being available if the contractor fails to close out. And that's why lenders set the floor at typically 10% through substantial completion, and why final retainage release goes through that same rigorous draw approval process as every other disbursement during the course of the project. It's simply not the owner's decision if a lender's involved just to release retainage when they're comfortable. And so the practical problem there is that, a contractor could satisfy every contractual obligation it has to the owner. The owner was ready to release the retainage, but the lender sign off wasn't coordinated either in the construction documents between the owner and lender beforehand, and the retainage could sit for months. And the lender in that case would have the upper hand just based off the terms of the loan agreement. And that is something that I don't recall specifically dealing with it personally, but it's something that does come up. And I think it probably happens more than it should, because there's an easy way to fix that with baking in kind of key language into your construction contracts. And we're going to talk about that in a little more detail in section 2. But when the lender's disbursement process for the retainage isn't factored into, the release trigger between the contractor and owner, well, then that's going to be an issue, right? And there's going to be potential delay to the contractor with potentially no recourse because the lender's holding the funds. And so, this kind of picks up here with the point I was just making, and something that I would kind of give as a kind of a first recommendation here. And it's a kind of straightforward concept, but it can be overlooked. And that's trying to marry, right, the terms of the loan and owner agreement, loan borrower agreement for the project, along and flow those down when relevant to the owner contractor deal in the contract. And so, in that instance, the owner is the common party across both negotiations, right? They're sitting at the table with the lender and on one track On the other side, they're dealing with the contractor. And so that means the owner and their counsel, in theory, they're in the best position to ensure that the lender requires, that flows down to the contractor. And if that coordination doesn't happen, then that can lead to problems. Now, I'm not saying if it doesn't happen that the owner's counsel or the owner is necessarily at fault. The contractor should be thinking about those same things and asking those questions as they're negotiating their construction contract with a finance deal. And so I think, in the ideal world, what should happen is if it's possible, there are two parallel negotiations running kind of simultaneously. On one track, the owner and lender, they're negotiating the loan deal. That will contain specific terms, draw submission documentation requirements, retainage, change order approval thresholds, completion standards, default, and cure. And so those are going to be the lender's right non-negotiable terms on a loan deal, and they're baked into that loan. But then on the other hand, the owner and the contractor, they're negotiating the construction contract. If it works out simultaneously or around the same time period. And the critical point being, if the lender's term sheet, making sure those key terms that are going to apply to the contractor get flowed down. And so if the loan agreement requires draw submissions, for example, by the 20th of each month, well, then you want to make sure your construction contract is going to require the general contractor to submit pay applications by the 18th or at least the 19th to build in some processing time, right? And if that is not set up in the beginning of the project, you're going to find that out real quick, and you're probably going to have to revise it. But getting ahead of that and thinking through that as you're drafting your contract is certainly important. And then the other example I'll give is just that the loan agreement requires 10% retainage. The construction contract should reflect that too, right? The lender requires unconditional lien waivers from all tiers before every draw, right? The construction contract needs to include that as well. And so mirroring all that up is just critical. And so when that coordination happens, you end up with a smooth process. If it doesn't happen, you end up with misaligned payments dates. You're going to have inconsistent retainage, the conflicting documentation, and all that. It's just going to lead to further delay, either for the owner or for the contractor as the work starts. And I'm going to show you in a few slides here a few kind of example provisions of things to think about as you're working through that. All right, so I put together here on slide 8, it's a kind of an example of how the draw process is going to work on a finance deal. And so we're talking about how the timeline of how the funds are going to flow down to the subcontractor in this case. And so I've got 6 steps here. Again, this is generally speaking, not all deals are going to be the exact same, but this is the typical process. So step 1 is going to be the general contractor, right, preparing or assembling their pay application. And so I've used just here as the examples, the AIA G702 and the G703, which are the cover sheet and the continuation form that are going to be submitted as part of the payment applications under the AIA contract documents. You're going to have an updated schedule of values. You're going to have the complete lien waiver package, whatever that's required on your project. Conditional waivers, unconditional waivers, and we'll get into more of that in a minute. Step 2 is going to be the architect is going to review that pay app, and they may conduct a site inspection. They may verify percentage completion on line items and then issue, if approved, a certificate of payment. And the architect, typically you'll see in the AIA structure, is that the architect is more like the owner's agent, right? That initial decision maker, you'll see that language. But kind of their certification by the architect is that first gate. And then the owner is going to take that certificate and all supporting backup documentation, and they're going to submit their formal draw request to the lender. And then the lender will have their own draw request form with specific requirements that the owner has to comply with. And it needs to be completed correctly and completely, because if it's incomplete, you're just going to cause delays in payment processing. And then step 4, I would say, on kind of again, assuming complex project, lender involvement, You may have it where the lender's construction third-party inspector may certify the work in place, visit the site, do a kind of a due diligence review of what that submission, the application may look like from the owner. The inspector is going to report to the bank. They're not reporting to the owner or contractor. And if there's issues, mismatching, things that are of concern, that could cause a delay in the process. And you could have a scenario where, okay, a lender is saying, hey, I'm only going to commit or pay 80% of this because 20 of this doesn't look right, but that's going to be a holdup. And again, the lender may have a third party inspector who's involved with that process. And then step 5 is the lender reviewing it, kind of the complete drop package. This is kind of in tandem with step 4. You've got the architect certificate, you got the inspector sign off, you have the lien waiver package, you'll do a title search, make sure there's no liens in the property. And if everything is in order, then you've got sufficient funds under the loan, then the lender's going to approve the draw. And but just as an example, and we'll talk about liens more, but certainly if there's a new lien that pops up, that's potentially going to delay the entire process here, and something that again is going to be spelled out in the loan documents and or the contractor documents of what needs to be done if there is a lien, either someone paying that contractor for the work and or bonding off that lien. And then assuming everything's going well, this has all been approved, maybe early on in the project, no issues. Funds are wired to the owner by the lender. Then the owner is going to pay that contractor within the time frame in their contract. And I'll just keep in mind that if you're not spelling that out specifically on terms of the timing of payment, then you're going to be subject to Georgia prompt pay requirements under 1311.1, and I'll go into that a bit more in a few minutes. Okay. So shifting gears a little bit, but I think this is certainly relevant. And if you've represented general contractors or owners on any of these finance deals, you're probably familiar with some of this terminology and requirements of a lender and some of the documentation that they may require before or right around the time that loan's being closed or the construction contracts being signed. And so typically, the lender, to ensure they're fully protected, they're going to require the owner and contractor, in addition to just the loan document, execute some key agreements that are going to establish their rights and make sure there's no ambiguity of who's in charge here. And so from that standpoint, I'm going to kind of combine a few of these, but you'll typically see where a lender could bundle these first 3 instruments together into a single document. So that's assignment of the construction contract, agreement to complete, and then subordination or consent to assignment rights. So I'm going to walk through these quickly. First on A and B, usually it's combined form. So it's the collateral assignment of the construction contract plus the step-in rights. And so the lender's greatest fear in an incomplete project, right, is a finished building not being completed, or the building not being completed, because if it's not, it's worth half the fraction of what the lender thought. So the lender is going to get the legal right to step into the owner's shoes and demand that the contractor keep working if the owner defaults. And in exchange, that contractor is going to get a direct payment commitment from the lender going forward. But typically, the critical limitation there is that the lender refuses liability for any amounts that the owner may have owed before the takeover. And so your client, as the contractor, may be required to keep building while they're owed significant money in exchange for, a promise of future payment. And that's something, as a contractor, you're going to have to protect yourselves from your construction contract, right? Like your rights against the owner, recovery of work done. The lender's going to say, no, that's owner's fault. He's typically in default if this is happening. And so in that case, your recourse for work performed is likely going to be against the owner, not necessarily the lender, even though the lender may be stepping in. And then there's subordination rights in instrument C. Again, this can be part of that same package. The lender wants written confirmation that the security deed is senior to every other claim on the project, including your your client's mechanics lien. So the contractor in this language or the agreement is going to acknowledge priority in writing to the lender, and it also establishes kind of a direct communication channel to the lender on notices, change orders, and things that maybe the lender wants direct notice of. So when the owner, if they start going sideways, that direct channel is often, and it could be a good thing for your client as a contractor to have a direct channel communication line with the lender on certain notice issues that may come up. And then instrument D here is just the lender, their inspection rights. So again, large complex project, inspector involved, they're going to want the right to come in and inspect the project if they want to. And so, it makes sense if you're a contractor and that's set up on your project, you're advising your clients to try to have a good relationship with the lender's inspector. They're the ones that are kind of calling the shots here, reporting to the lender. And so when that's in case, it makes sense to make sure you're accommodating their request as they come up. And I think just from a practical standpoint, this is an example I had. I just flagged this from, it was representing a general contractor, large, multi-purpose development going on. I think it was in Tennessee on this deal I was involved with. And we got one of these forms from the lender, right, about the conditional assignment agreement. And I'll just tell you, from the practical standpoint, lenders got the leverage here, right? This is their loan. They're calling the shots. We pushed back a little bit on tweaking some of the language in that agreement and did try to propose some more cure periods if the owner goes, it goes under or is in default, and trying to get some coverage from the lender directly if the payment, if the owner can't make payment. But in reality, the lender is like, no, we're not doing that. Here's what we're going to do. And so I think, you may get some traction here when it comes to negotiating or redlining back that form you get from the lender. But I think big picture, you just got to understand that you can't expect to reshape what's going to be their document there. And if you go in with targeted, reasonable asks, then you may get some flexibility. But I think you want to advise your clients on that, right? Like I can recall my client sending me that form from the lender, and they're like, "What is this?" Right? And so having to explain that to them, that process, making sure they understand it's not really optional. It's going to be something you're gonna need to sign for them to close the deal. And then let's look at it closely and see what we really need when we go back to the lender. And then a lot of words on this slide. I know Neil Sweeney wouldn't appreciate this slide, and so I'm going to keep it high level. I think from what is the bank watching when they approve or when the work starts. You're looking at the draw requests. They're going to be reviewed line by line against an approved budget. Percent complete. That's going to be independently verified by the lender's inspector. You're going to have the schedule, certainly monitoring the baseline that was submitted at closing, because if that schedule depletes, then that's affecting interest reserve deadlines, liquidated damages, everything in that capacity. And then you're looking at monthly budget, percent complete. They're going to be looking at title searches again, making sure there's no liens on the property. And then also another one is like the ongoing borrower covenant compliance, right? The borrower or the owner under the loan agreement is making certain representations to that lender. And so the lender is going to be monitoring that as well. And so those are all potential red flags for when a lender could freeze that draw. And this slide kind of touches on, that same thing. Lien activity, that's going to slow it down. Discrepancies in the billing, that's going to be an issue. I'll flag here, what is this concept of monthly pencil review? I've negotiated this, and I'm sure a lot of people have or have discussed it with their clients. You can, when you're negotiating that AIA contract, typically in just say the A102 for your construction, for your contractor with the owner, and you're spelling out the timing of that payment application. One thing I've baked into prior deals, and some clients like it, some others don't, is just this kind of pencil review process where you put it into the contract that prior to the contractor actually submitting its formal payment application, you say within 48 hours before that meeting or before that deadline, you're going to have an owner's rep, a contractor's rep, and maybe the architect required to attend the meeting. It could be 30 minutes or an hour, but just to go through the forthcoming payment application. And so by, setting that process into the contract, you're saying, okay, it's not just that the contractor is going to submit their payment application blindly and hope everyone accepts it. The idea is that you're sitting down before that submission and working through that payment application to get everyone on the same page with percent complete, with budget line items, the schedule of values. And if you do that, then you may have more success. And once that payment application is submitted, everyone's on the same page. They know it's forthcoming. And in that case, maybe just a quicker payment process with no hiccups. One additional point, it's actually not on the slide, but I was thinking about it earlier. When I've been involved on larger litigation where, if I'm representing the contractor or the owner, regardless, the owner on these finance deals are going to have a lot of reporting obligations up to the lender, right? And that's maybe just monthly, but they're going to have detailed summaries, updated schedules, kind of a package that they're submitting with, updates as the project is progressing, percent complete, all these things. And that's all going to be in writing. It's all going to be provided up to the lender. They're going to require it. And so what I've seen in litigation that comes up is this disconnect between what the owner is reporting to the lender and then what they're representing to the contractor at the same time during the project. Now, the contractor is not going to necessarily have that documentation during the project, but in litigation, you better believe if I'm representing the contractor, that's one of the first things I'm asking for in discovery is I want all your monthly reporting to the lender on the deal, right? And so an owner, it's hard to expect and anticipate and change your monthly reporting in anticipation of litigation 3 years down the road. But you just better recognize that whatever you're putting in those updates, to the extent you're, I won't say manipulating, but just modifying schedules to the benefit of the whole, keeping the lender happy. If you're reporting X and then telling the contractor Y, and the contractor feels like, hey, owner's not being fully transparent here, well, some of that's going to come out in discovery and litigation. So just keep that in mind. I won't spend too much time here, but this is, the priority of lien priority. Construction lender is going to be up top, but I think important nuance here is, delinquent property taxes can have super priority in Georgia and in other states. So you can keep that in mind, but this is a little bit more of a high level slide and certainly very specific, based off the nature of the project and any of the liens that may be at issue. And then this one, my orange disclaimer of do not do if you can avoid it. And it's just something recent as I was putting this together because I had a general contractor client that we went through litigation just late last year. It was a deal where they had signed a contract with a tenant for a major kind of tenant improvement build out. And the tenant had assured my client and everyone had the understanding that the financing was in process or done. And so my client, before I was involved, the GC was eager to keep their schedule. They started the work. They went for about 2 months. And then they started asking questions about the financing. Things aren't showing up. And of course, the financing fell through. And so because my construction client for my client was only with the tenant, not the landlord, and there was no landlord joined or expressed approval in that contract or under the landlord agreement. My GC's right for that work was very limited, right, under Georgia law, and because I could not go directly against the landlord. Essentially, what I ended up with was a mechanics lien against a leasehold interest. Now, fortunately or unfortunately, there was another portion of that project where my client had directly contracted with the landlord for some underground sewer work. And so we ended up going to litigation for this unpaid work. That became the focus of the litigation, the unpaid change order work. We tried to bring in some of these kind of equitable arguments that can exist to the fact that we improved this property and the financing went done. and certain representations, including from the landlord, were made to my client. We ended up getting actually a partial payment of that work in the award. But big picture, it was one of those things where my client looks back and said, "Yeah, we're never going to do this again. We're never starting work unless we know absolutely that the financing is solidified." All right, we got about 20 minutes left. I'm doing pretty good on timing. Section 2, payment procedures in the contract. So we talked about lenders think, and so this is going to be more getting into the documents and clauses from the kind of foundation of the payment cycle. And I'll spend some time, I think, on these kind of three foundational documents. I think everyone will probably be generally familiar with these documents, but the schedule of value, that's the billing roadmap for the entire project. Every pay application is going to trace back to that. The schedule of value is going to break the contract into line items. So foundation, structural, steel, MEP, finishes, and so on. That's each going to be tracked and billed against each month. And then a well-constructed schedule of value should reflect the actual cost distribution of the work, and it's reviewed by the architect and the lender before that pay app goes in. Document 2 is that application for payment we talked about a little bit earlier. That's the monthly invoice. In the AIA world, it's the AIA G702 cover sheet, and then the 703 continuation. The 702 is going to summarize the total contract amount earned to date, retainage, net amount due. And then the G703 is going to break it down line by line, showing the schedule value item, the original value of the work completed, stored materials, retainage, all that. And so under the typical AIA structure, the kind of the default, right? If you get the template, is the application is submitted no later than the 25th of the month, right? To align with the lender's draw cycle. And you're going to have to include conditional lien waivers from the contractor and subcontractors for that draw. And then you're going to have to include unconditional waivers from all tiers, from all the prior draws, right? For what you've been paid for. And again, I forget the notes on the slide here, but this is where you would want to potentially bake in this concept of a pencil review, or even if you could make it, because what happens is you put that into your contract. Hey, you have to meet 48 hours before each meeting. Well, maybe that's difficult. Maybe on a month-by-month basis, that's not absolutely necessary, or the parties get comfortable and saying, "Hey, we don't need to do this." You could bake in some good faith, if available, accommodation language that says, "Hey, they'll make their best efforts. The parties will make their best efforts to meet at least 48 hours in advance of the application to review and discuss any changes." And then document 3 is that retainage schedule. That document's going to track the holdback amount, right? When it gets reduced, a default percentage of 10% retainage is typically what you'll see. Although there's a lot of variations, and I'm actually I'll talk to that here in a minute. And so these three, I think the takeaway here is these are kind of the engine that are going to get you paid, these documents. And so you want to pay attention to that, make sure again you're comfortable with those clauses, and those forms. The contractor, they're certainly going to be very familiar with these, and it's not like typically when I'm involved, it's not like I'm involved in reviewing pay apps and filling out these forms. But even from a counsel outside standpoint, you want to be generally familiar with these, because this is how, if you get into litigation, this is how you're kind of establishing your damages, the retainage withheld, the timing of payments, all these things. These are the documents that are going to be your exhibits in the litigation. All right, so I've got 5 clauses. I'm going to try to run through these quickly and kind of some examples. Everyone can screenshot this and steal my language, but I think you'll see that this is all fairly common stuff. On the one hand here, the timing and conditions precedent to payment. Here you can see in the red, that's the contractor shall submit pay applications monthly. Well, probably about as poorly written as you could go with, right? No details, no deadlines. You're just going to run into issues there. And so the recommended language there is on the right, very more specific of what needs to be required. You've got, the date, you've got the schedule of values, the loan, the lien waivers, the unconditional waivers, and any other backup that the owner or lender may require, right? So that's that catch-all language that typically, if I'm an owner, I'm making sure that anything's got to be per the lender requirements, right? And so that's some language that you're going to want to keep in there. All right. Let's go retainage two on clause two. Retainage again, I think the note up top is just how significant the retainage can be. And I think there's a lot more, and I see this on most deals where this is going to be a clause that can be negotiated depending on the type of project, the lender, the type of work, how long the project is going to be dragged out. And so, one way to think about it, in terms of, you'll see this is kind of a different setup. I'm giving the example on the left of like a 50% completion reduction. So you could push for this, right? And the idea here is that from a contractor standpoint, you would say that once the project hits 50% complete, well, then retainage drops to 5% on all future payments. And then the excess above 5%, which was withheld, is released at that milestone. And so you would push for that in your negotiation. You would have to make sure that's flowed down and probably get lender approval, right? The owners shouldn't be agreeing to that, right, unless they've got lender approval and sign off. And I think the issue there is just a cash flow issue. It's a common practice where, especially on early tier subs, um, where you want to get some of that money back to these subs that have completed their work. And it's also just establishing the kind of the good relationship of maybe a project progressing well. Sometimes you can kind of have language in there that's even like optional, like up to lender's discretion, right? And that's something at least you could try to get into your contract from a contractor standpoint. And then if everything's going well, maybe you get the lender to say, yeah, that's fine, we'll do it. And then also worth knowing just kind of the early release retainage for subs who complete their work early. And that's one just last week. That was something we had baked into our deal. The owner agreed, the lender agreed. And so sometimes it's right. The critical aspect there is you've got the site work, foundations, concrete subs. If they have very specific scopes, they're done with their work, the retainage is getting held, and there's a potential that they're going to have to file a lien, right, to recover on any amounts that they haven't been paid. So you set that up in your contract. The lender's going to like that if they can avoid, right, any lien exposure that may be forthcoming, and then you get those subs paid early. And so that's something that I see baked into deals. And then kind of the final release of retainage, another important clause where you want to define that final release with specificity. The owner satisfaction typically is not going to be your trigger. You're going to want, kind of 30 days after substantial certificate of substantial completion, all the lien waivers, all the documentation, the warranty, anything you need from a lender owner standpoint, you want to kind of make sure that's fully spelled out before or as you're negotiating your deal. Change orders, I won't spend too much time here, but these are some provisions to fight for of change order and lender approval. And I think, the concept here is that there could be a threshold built into the loan agreement of, hey, if the change order exceeds $100,000 or whatever it may be, then it needs to get lender approval. And so you need to think about those type of things depending on the type of work, of how you're structuring your deal. And so you've got in here kind of some timing of when you're going to have the owner have to approve it. If I'm the contractor, if you can get in some language saying, hey, if you don't approve it affirmatively within 10 days, it's deemed approved. If I'm an owner, I would never agree to that. And so that's just some back and forth to be thinking about. Yeah, and I think the other note I have here is just on kind of the lender coordination, right? And if a change order is over X amount, you could think about, as an owner, building in a threshold timing requirement where there's more timing allowed for the lender to review it and approve it before having to make a change order approval of over $100,000, for example. The lender alignment of the draw schedule, this is, what I think I touched on this earlier, but kind of like the one critical thing I'd say take away here, right, is this. It's just making sure you're aligned in that construction contract with the owner lender agreement. And that was the example I gave with, if the owner's pay app has to be submitted by the 25th, if you're making sure you're baking in a few days for the contractor to submit its pay application to the owner and be reviewed and approved. Um, trying to think let's see, on the 12.14 there. So this is lender failure to fund, right? So this is example of owner language where the saying the owner should not be in default if failure to pay is directly caused by the lender's refusal to fund, provided that the owner is not in default of that loan agreement and everything was timely submitted. So the owner may say, hey, they have to immediately notify the contractor of any lender refusal on the specific basis, for that within a certain time period. And so that would be something that the owner may push for. But right, if I'm representing the GC, that's something I would push back on, certainly, right? Like on this language at a minimum to negotiate protections for you that, if you don't have recourse against the lender, that's not a risk that you can control negotiating that deal. And so, that clause that I'm looking at 12.14 as an example from the owner is essentially saying the owner is not in default if your client doesn't get paid. But from the contractor seat, that's a meaningful concession. You're essentially agreeing that a third party's decision, right, one that's not in your control, excuses the owner's payment entirely. So, there's ways that you can think about eliminating that provision. Certainly, probably would start there. The notice requirement is it's kind of that minimum protection you would fight for and push for kind of immediate notice of that issue. And then from a contractor standpoint, the other portion of the AIA that you could then fall back on is maybe your right to stop work, right? If the lender refuses, or if there's no default of the owner or lender. And then so I just touched on this owner's right to stop work. That's something you could consider baking in if they fail to make payment, right? For example, here, and some of this it's in Article 9 of the A201. They fail to make payment within 7 days after written notice, then that gives you some protection to stop work and you're not continuing to have to work because there's an owner lender issue under that loan agreement. You have some rights as contractor where you're at least covered as some of that payment issues get ironed out. And then I put together a drafting checklist. I won't go through all these. A lot of this we've kind of really already touched on. It's payment timing. It's the condition precedents to the submission of your pay applications, the lien waivers, the retainage, looking at that clause, change order approval of the lender, and then lender alignment, right? The timing, all that in pretty good detail, I think has been covered. On pay if paid, that this sits right at the intersection, right, of contract drafting and then what's required under Georgia law. And so the rule in Georgia, right, the courts are going to enforce a true pay if paid clause as long as it's expressed and the condition precedent language is clear. But vague language is going to default to pay when paid, right? So the difference, very generally, right, pay if paid, the general contractor owes nothing until that owner pays them. Pay when paid, right? The general contractor owes the money, usually a reasonable time period, and payment is just delayed. And so if you're representing the GC, express condition precedent language, payment is expressly conditioned upon. Some of the subcontractor assumes the risk of owner non-payment, right? So this is flowing down to your subcontractor. And certainly if I'm the GC, I need to make sure that whatever language I get stuck with or gets agreed to with the owner, that's then flowed down to my subs, and I'm not getting in a position where I have to go pay my subs if it is pay if paid. This is ultimately going to lead to lien issues, right? Especially if the language is not clearly spelled out, and so those are something you need to be paying attention to on any of your deals. The express language of payment and whether the owner payment is pay if paid or not. And then prompt pay too, again, you can write into your contract, specific timeframes for payment, right? And you can agree to those. The prompt pay statute is more of kind of that minimum threshold or the baseline, the statutory floor. You can contract around it, but you better be clear And if you go back to think back one of those slides where it was very ambiguous saying, hey, we'll submit payment, at a certain time period, and then we have to pay you within 30 days with no other details. Well, then some of this is all going to kind of be baked in. You're going to want to look at 1311.1 as your basis for understanding any risk that you have with increased payment and obligations to pay down tier either contractors or suppliers or subs. And if you look at that statute, you'll see that there are specific requirements for once you receive payment from the owner, if you're the general contractor, or even if you're a subcontractor, that statute is going to require you to pay within X amount of days. And if you don't, there's going to be statutory interest that's going to apply to those payments. And then, obviously we could do a whole CLE on Georgia lien law. I'll flag this. You've got this in the presentation materials. Certainly there's, strict requirement, compliance in terms of any notice of commencement filings, the preliminary notice requirements of when you're starting the work, the lien filing deadlines, bonds to release liens, and then the priority of liens. So I won't go into too much detail here with 4 minutes left, but I'm sure you can find some good material on everything that's required with liens. And I think as we kind of talked about earlier, the lender is certainly going to be on top of with every pay app, any lien exposure on their property. They're gonna either push one to likely either have the owner handle it if that's an owner issue and they haven't timely been paying their contractor, or they're going to have their protection under the bond and any requirements in the contract documents for example, the GC to go bond around that lien and get it off the property title. All right, and then very quickly at the end, Section 3 doesn't get much attention, just protecting your client. These are, I think, just kind of overlap of what we've talked about. The conditional lien waivers, the lien waivers, the down tier waivers, all that's going to be included as part of your pay app, right? The conditional waiver becomes effective only upon the actual receipt of payment. The waiver is contingent on that money clearing. Then the unconditional, it's effective kind of regardless of whether payment is issued. And so you want to be careful, right? Any unconditional, you better have the money in hand and finalize, and there's no questions before you sign that lien waiver. And then on the title bring down, that's again, the title company is going to be running for the lender, the lien search, and those are going to be obligations flowing down to the GC. And I've got some practical strategies. Before the contract, I talked about getting that loan commitment letter, making sure the financing is in place. During construction, aligning with those lender draws, all the backup documentation, the pencil review concept. And then when trouble appears, I'm flagging, obviously being proactive, communicating, but then you've got some protections that you can try to bake into your contract or even default AIA, which is that stop work notice obligations or requirements that you may have in your contract. And then, so key takeaways with 2 minutes left. I've got, again, stepping back, construction lender heavily involved. They're controlling the money. You want to understand that relationship of the lender and the priorities and what's important to them. And some of that's going to be based off of the borrower, the owner, their track record, the type of project, the location, all those things, the market, right? Anything can kind of be affecting the lender with all their money involved and invested on this deal. The priority of that documentation that the lender is maybe going to require of the owner or GC. You want to be aware of that, educate your clients on what may be required in terms of what the lenders are going to require of mechanics liens and their priority on the project. Negotiating that loan agreement and the construction contract in tandem. If you can do it, fantastic. And then, I think it's on both owner and contractor counsel to make sure they're getting a full understanding of what's required with the lender, so they're not running into issues for their client once the construction starts. And then the foundation documents I talked about, you want to be familiar with those. Schedule of values, pay app, retainage, all those are going to be important to get your client paid for the work it's done. And then as red flags appear, proactive discussions, the stop work, the lien notices, all those things that you can be on top of. So I think that's it right at 1 o'clock. Thank you all for attending, and again, appreciate Georgia Bar, Atlanta Bar for the opportunity, and I hope to see you at these future events going forward.
Yeah, real quick, thanks, Bill. I think we have one question. I think it is, I don't see it in the chat, but Lane said that we had a question. So I don't know if Lane can
It
jump
says
back.
any good theories slash case law for claims against lenders for recommending and or approving draws to scam contractors.
Yeah, not right offhand in terms of specific cases. I'm happy to whoever it was asked the question to reach back out directly. Actually, on the last slide that I pulled down in the materials is my email. But I'd be happy to kind of talk through any specific case law and understand that issue specifically. I didn't put too much case law into here. I did look into a few cases, but I think for the purpose of the discussion, it was difficult to try to bake in specific case law here. So happy to have that discussion.
All right. Well, thanks again, Bill. And this closes it out for everybody today. It's very informative. I appreciate your time and the effort putting this together. Look forward to seeing everybody on March 20th for project scheduling and schedule claims. Thank you very much.